Hi, my name is Monique Libby, and I'm here today to talk to you about copyright, fair use, and research libraries. Because libraries are often the most common place where patrons are provided with access to a vast majority of copyrighted material, and we need to be able to distinguish for our patrons and to help them with fair use and to obey copyright. Here's an abridged timeline of the way copyright law has evolved over time in the United States. And also there's a note here with the World Intellectual Property Organization, WIPO, at the very end. But you can find a full timeline available at arl.org's website. I'm going to begin by introducing the root of all copyright law, which is the Copyright Act of 1790, which was passed by the first Congress and was the first copyright provision to the U.S. Constitution in 1790. It was meant to encourage learning through securing copies of maps, charts, and books in order to provide authors and proprietors with an incentive to print or publish their work and to protect it for 14 years and give them the right to renew it for another 14. It wasn't until 1909 which the first major revision of this act happened, and it increased the scope of protection to include all works of authorship for another 28 years. In 1831, the first registration period was increased to 28 years, and now in 1909, authors and copyright holders were able to increase their protection from what was 14 years now to 28. And it wasn't until 1998 where the Digital Millennium Copyright Act had sought to have copyright law meet the technological advances that had been made in the United States and around the world via the World Wide Web, and how to protect digital material and computer software and other digitized materials that could easily be shared on the World Wide Web. The 1976 revision attempted to close the gap between copyright law and technological advancement, but it didn't. Obviously, there were a lot of advances made since the 1970s. The Digital Millennium Copyright Act still has an impact on the way that we use copyright material today and how we exchange computer software and share items and content via the web. In 2006, orphan works were taken into account, and people were able to obtain permission and be free of being accused of infringement or being sued if they performed due diligence. And this documented process is very strict, and also it gave the copyright holder the opportunity to reclaim their work if they chose to do so. And then we jump to 2007 with the Fair Use Act. This act was introduced by Congressman Rick Boucher in order to protect the fair use rights of consumers and also to enable libraries to preserve works via Section 107 of the Copyright Act. This act did not pass. Internationally, WIPO, the World Intellectual Property Organization, sought to also take into account the limits and exceptions of copyright in regard to education and accessibility for patrons. The 2012 exemptions to provisions of the DCMA Act finally took into account how digital content and computer software needed to be circumvented in order to serve patrons for educational purposes and to provide accessibility to patrons who had disabilities that were, for example, visually impaired, to be able to have the material replicated in order for it to be understood by a screen reader, and also to have material available for people with print disabilities. Here, Copyright Law of the United States, Title 17, Chapter 1, Circular 92, says fair use is includes the reproduction and copies or phonorecords by any other means specified by that section for the purposes such as criticism, comment, news reporting, teaching, so educational use, academic use, research, which is not an infringement of copyright, meaning that a copywritten item can be used in a way that promotes knowledge, informs people, but still does not take away from the value of the rights holder and their material. It's kind of difficult to balance copyright law in a library, and also it's difficult to monitor how patrons seek to use the material. More often than not, fair use can be misinterpreted, and it's very difficult to distinguish what is obviously in the public domain, which is material that is authored pre-23, so 1922 and older, and then copyright, which is restricted. Here are some facts to know about copyright law. Fair use can be ambiguous, and it is also flexible. You have to take into account the scenario in which the material is being used. It is a case-by-case basis, and you have to sort of use your own judgment and decide what would be declared fair use. There's also no substitute for obtaining copyright permission. So obviously, if material is post-1922, you have to seek permission to use it, unless it is stated that it is in the public domain. And then occasionally, while most government materials are considered to be in the public domain, sometimes they're co-authored by private institutions or published by private academic institutions. For example, the Freer-Sackler Museum, which is also a government agency under the Smithsonian Institution, could publish its Oriental works through University of Michigan Press, meaning that these supposed government copies of materials would be under restricted use because they were not published by the government printing office. They were published by University of Michigan. So the works may be available to you, but you need to be able to, you have to obtain permission in order to use them for other purposes. You also, as a library staff member, need to consult licensing agreements when helping patrons with materials. This needs to be done on a regular basis because the agreements with certain database companies and other co-institutions might have specifications on how to share the material. For example, right now at the Council on Foreign Relations, where I presently work, the Financial Times does not want our users to copy and paste articles from their website. Even though we have a subscription that we pay for, they do not want our users doing that. Instead, they would rather that users use their system and save the articles that they would like to keep in a folder, which is provided through their user account, or they can gift articles using their system to send articles up to 20 to people in other institutions. But they do not want users copying and pasting full articles or any portion of articles and distributing them that way. And another thing to take into account is that online images may be protected by copyright law. So just because it's online doesn't mean that it's in the public domain. Yes, the public can see it, share it, look at it, but you are not able to use it freely for your own purposes. Here are some resources on copyright law for fellow librarians and other information professionals. Here there's the ALA Fair Use Elevator Tool. There's a link to EFLA's Legal Matters Advisory Committee, and also to WIPO's World Copyright Treaty. Thank you, everybody. Please feel free to ask me any questions and post them to the discussion board by this time. I believe that's the date. And here are my sources that I used for the presentation. Thank you.